All right. Hi, everyone. This is Curt
And Bill Podszus.
All right. And we are here for another edition of Fire Law Roundup for, let's see, today is the 18th of September, 2023. And I just am anticipating, I am anticipating a little problem. Nope, it looks like we're not going to have that AV problem that we always seem to keep having. I am in Annapolis, Maryland. Obviously, I'm not in my office. I'm in a hotel room, and I don't know how the acoustics and the quality is. And I'm going to tell you, I'm not sure how the quality of my presentation is going to go because I'm exhausted. I got about 4 hours sleep. I had a 6 a.m. flight down here. So, but at any rate, we do have an interesting week. Bill and I were just kind of mulling that over before we got started here. But let's get into the first case. And this is one I added to the case last night. It's a case out of Michigan. Bill, did you have a chance to look at it?
I did. I was only able to skim the complaint, but I got the gist of it.
Yeah, and an interesting claim here. Now, we have a fire chief who apparently he received a complaint about from a female about sexual harassment. He didn't do it the way I recommend it be done, but he handled it in accordance with his department's way of handling it, which is fine. I mean, you don't have to do it. I recommend you do it the professional standards way. Bill, I know as a former police officer, you know the way that a police department would handle a complaint like that. And you know, you assign it to a professional standards investigator, formal investigation, and so on and so forth, or you refer to HR, however. But he had a battalion chief handle it, and the battalion chief felt like he handled it, and apparently she felt like he hadn't. A second complaint came in. He assigned the same BC, and it's a little unclear what happened after that, but the bottom line is she ends up going to the town manager. The town manager is upset about the way that the chief handled it. It appears the town manager had some bad information, whether she told them that the chief didn't do anything, or he assumed the chief didn't do anything. But in fact, the chief had done something. And they launched this investigation, which the chief alleges was unfair. And at the end of the investigation, he ends up getting terminated. And so he's filed suit now, claiming that he didn't have a right to a hearing. He's claiming a liberty interest under due process. He's also seeking a mandamus, which is a court order to rectify some sort of an administrative decision that should have been made in a certain way. And he's claiming that that decision on his discipline was made improperly, and he wants to have a court review it. Well, Bill, what was your sense from reading it?
My read on it is that the chief did what he was supposed to do.
Right.
I thought the complaint was very well drafted. I just wasn't able to read it in great detail. It's rather lengthy, but it seems to me that the municipality's approach to this was perhaps not as well thought through as it should have been. They're meeting with an employee in a coffee shop or a diner. It just kind of screams impropriety. Why aren't we meeting in City Hall or in headquarters or wherever? Why are we going outside the chain of command, et cetera, et cetera? I didn't see a request to go outside the chain of command in there. I thought what the chief did was, and of course, as we always say, we only know one side of the story here. It looked to me like he proceeded in the proper way. It's his right to delegate it. Perhaps the battalion chief is closer to the situation, knows more about it, knows the people involved. To me, it seemed perfectly reasonable what he did. And it didn't seem that the chief was given an opportunity to say, well, this is what I did.
Yeah, and he did at some point, he did present his evidence that he had done an investigation and he had a report and all that. And the person who was assigned to investigate it was very I guess, surprised, because he must have been briefed by the town manager that the chief hadn't investigated it. So there was a little bit of a surprise and shock that, oh, you mean you did investigate it, and oh, you did document it? And so there was some questions there. But I think when we take a step back, the chief is an at-will employee, and that much is pretty clear. And so if they had to find cause, I think they'd have a problem. I think the township would have a problem. But because he's at will, he doesn't have a right to only be terminated for just cause. So even if he did the right thing, he doesn't really have a right to just cause. So I think that's going to be problem number one for him. And the second part of it is the mandamus. The mandamus is he's got to establish that they had a legal duty to make a certain decision, and they screwed up that decision. I'm not sure he's going to be able to make it on those. I mean, I'm sympathetic to the chief. I think the chief did do what he was supposed to do, at least according to his training and his SOPs. I just don't know if he's going to get a remedy, in court.
I didn't understand the bringing in of a private investigator into this. Why is this not investigated?
It's fairly common.
Is it really?
Oh yeah, it's for fire. Now, police, you never do that. You don't need to, because you have trained investigators. But in fire departments, yeah, there's a lot of people, and I'm not one of them. There's a lot of people out there that recommend that a fire department always bring in outside investigators. And I get it. I have one son that was a firefighter. He's now gone on. He's a doctor now. But I have another son that's a police officer. But my son that was going to be a firefighter, he never crossed his radar screen that at some point he may have to do an investigation. It just wasn't what he was thinking of. Whereas my son that was a police officer, from when he decided he wanted to be a police officer and he went to criminal college to get his degree in criminal justice, he knew he was going to have to do investigations. And just that thinking about the whole skill set that you develop to do investigations, most firefighters don't have that. So I think we've got to develop that capability if we don't want to be investigated by outsiders. I guess that's how I look at it.
As I read the account of the investigation in the complaint, what jumped off the page at me was, this is not how you do an investigation.
Correct.
At least not in my world.
Well, there's two now. Because I can find fault with both of them. You had the investigation the fire department did, and then you had the investigation of the fire chief
from the city.
By the city, yeah. So which one did
the investigation by the city against the fire
of the chief?
To me was very unusual in its approach.
Predetermined, I think. Predetermined was the term that the chief referred to it as.
In the police department, we call it a witch hunt.
Yeah, as lawyers, we call it witch hunts too. But he referred to it as a sham investigation. And, there's a couple of points, and I agree with you 100% that when the investigator starts losing his temper, and starts going from information gathering to accusatory, that's where you've got an investigator that's already reached a conclusion and now is trying to shape the testimony to fit the narrative. And that's a problem. But I do want to back up a little bit to the chief's investigation. And earlier I kind of mentioned that it isn't the way that I would recommend an investigation be done. Now, this is the chief's investigation. And the best practice is that we don't want the fire chief to be involved in investigations. Now, some departments, the chief is going to have to be. Okay, but what we want is an intermediary officer, usually a four bugle chief, whether you call it an assistant chief or deputy chief. But we want someone who's going to quarterback the investigation, that has direct access to the chief, but that is able to make certain types of decisions. And one of the most important decisions when a complaint comes in is going to be who is going to investigate it. And so that's the first, I think, problem here, is that the chief of department assigned a battalion chief who had some involvement in this. and there wasn't any, like, you definitely don't want to have someone conducting an investigation into something that they were personally involved in.
Of course not. Of course
Okay,
not.
so that was sort of problem number one. And then the reporting went right back to the fire chief. And you really want to have that intermediate officer. And I think in law enforcement, you guys do this. It just happens because you've been doing it right all along. And you have, whoever your head of internal affairs is or professional standards, they're the ones that sort of quarterback the investigation. And then that leaves the police chief in a position where at the end of the day, somebody's got to make a decision. You're going to be demoted. You're going to get a suspension. You're going to be terminated, whatever it is. That person hasn't had direct involvement in the investigation. So they're independent in terms of objectively looking at the results of the investigation.
Well, in the job I came from, I was very frequently assigned to investigate infractions by my own guys.
Mhm.
The first line supervisor is the closest to the level of execution.
Mhm.
Perhaps you want somebody who was there.
Not if they're going to be a witness.
Well, not necessarily be a witness,
and not if they were potentially involved in the wrongdoing.
No, but what I'm getting at is you can very often put an end to things by saying, no, I was there.
Yeah.
Right.
Right.
I know exactly what happened.
Right.
Nowadays, so much is on video.
Right. And I would say that is a witness.
Oh, absolutely.
But that is not the investigator.
And that's one of the things that I noticed in this whole process is where's the lieutenant for this firefighter or these firefighters? Where's the captain for these firefighters? What's their involvement?
Hiding.
If they're smart, if they can.
So, yeah.
As a general rule, things that rose to the level of crimes went to internal affairs,
Right.
but not always.
Yeah.
I had one that was assigned to me where the complaint against the police officer was he raped my wife. Now that's quite an investigation to get handed.
Yeah, that is not something we want. Now, again, I think the model here is that all complaints, whether they come from outside the organization or inside the organization, go to that four-bugle position. And I refer to that as the chief of professional standards. It could be the chief of ops, it could be the chief of admin, but basically whatever four-bugle position gets that. Then that person looks at the allegations, just like you're discussing, and makes a decision. No, I'm going to have the captain do this one. This is a minor thing. It's, we're going to have the captain do it. Okay. Or they're going to say, this is a little bit more serious, and we're going to have internal affairs do the investigation. But what we want is consistency, because in a fire department, if you have 70 lieutenants or 70 lieutenants, 35 captains, you're going to have 100 and something ways of making that decision. You don't want officers making that decision. We need to standardize that decision making, and that's that four-bugle chief's job, is to make that decision consistently. Is it going to go to the lieutenant? Is it going to go to a captain? Is it going to go to battalion chief? Is it going to go to internal affairs on a day-to-day basis in a way that's consistent, and isn't going to say, wow, for these people, the favored sons, we're going to handle it one way, and for the disfavored sons, we're going to handle it the other way, and for females, we're going to handle it this way, and for African Americans, we're going to handle it that way. Because if you don't do it in a standardized way, you open yourself up to all these allegations.
Right. But one of the things, or at least what the complaint says, is that the chief did it in the standardized way that the department,
and I'm not
correct.
Right. And I am not disputing that.
So if the procedure is wrong, well, then change the procedure.
Exactly. And, let's face it, he may not have had any training in this area. So many people get into that, and they're trained to do it the way they've done it, the way that their predecessors have done it. They've seen it done, but they don't have any formal training in it. And when we think about what our training requirements are for firefighters, training on how to handle a disciplinary complaint is not in the top 100 things.
No, absolutely not. But it's part of police supervision.
Exactly.
You're given training in that when you go to supervisor school. That's part of it.
Well, we're not.
But the police department routinely gets more complaints than the fire department.
About 100 to 1.
So, but it underscores the importance really of documenting everything that you did. The ability for that chief to say, wait a minute, my documentation's right across the hall. That's worth its weight in gold.
I have a great deal of sympathy for the chief in this situation. I think, again, he did the right thing. And unfortunately, I'm not sure he's going to get what he deserves out of the court. But, you take your swing and you see what happens.
Well, he's got an impressive background.
Yeah. All right, let's move on to the next one here. Another interesting case here. This one's a collective bargaining case, or a union president who alleges that he was terminated in retaliation for his union activities and for advocating on behalf of his IAFF local. So we have the union president in Mountain View Fire Protection District in Colorado, who was terminated earlier this year. And he was accused of disseminating confidential information about a particular employee's religious accommodation request. Apparently, they had hired a Jehovah's Witness who had requested that he not be required to have any American flags on his gear or his uniform, and not be required to raise and lower the American flag. And the department was apparently working toward that. And the union president, I guess, was a captain, and he became aware of the what he thought was an unusual request. He made some inquiries, and it's unclear whether he was being a busybody or whether he was legitimately acting on behalf of the union or in his other capacity as a quartermaster or an assistant quartermaster. But he starts asking questions, asking around, and eventually he gets with the district's HR specialist, who sort of reluctantly, I guess, fills him in as to why this person is not going to have the flags. And I think at this point, it's pretty clear now he's doing it as a union rep. He's saying, well, the folks have got to get trained. And I mean, I can see myself doing that. I want to make sure my people are not going to get themselves in trouble. We need to make sure that everybody's educated, that this is a legitimate accommodation. They shouldn't be harassing them and that kind of thing. So they discuss that. And apparently there's some additional discussions that take place. And at any rate, he at one point has a blowout with the fire chief over something that's totally unrelated to this. And the next thing he knows, he's under investigation for disseminating confidential information related to the same person. And then he is terminated. So he is suing, let's see, what are the allegations are, a 14th Amendment due process right now. I'm assuming he can only be disciplined or terminated for cause or just cause. So that's going to be one big difference between him and the chief in the last case, where he has a right to procedural due process. He's also alleging that his free speech rights, and his right to free association, which I'm assuming both First Amendment and the freedom of association is going to be connected with the union activities. And then it's kind of a weird name for this, but they call it the Colorado Firefighter Safety Act, which essentially is a collective bargaining law for firefighters in Colorado, but it gives firefighters the right to engage in concerted activities for the mutual aid and protection. So what that does is that gives him basically a cause of action to say that the department is infringing on both him and the union's ability to protect each other and discuss things and so on. So we'll see how this one. What's your thoughts? You must have been in a union as a police officer.
Yes, and the flag issue came up then too, but not with this wrinkle to it. I think if I were in his position as the assistant quartermaster, I would ask the same questions. Mm-hmm. Why is this set of gear different from everybody else's set of gear? And as you said, is he being a busybody, or is he making a legitimate inquiry?
Mhm.
And I see no harm in asking the question, especially when, it seems from what we're given is that he's working collaboratively with the city and the HR people. And like you said, okay, well, if this is the case, then we need to teach people. And it's not just teaching the members of his company.
Mhm.
You got to train the whole job.
Yeah. Well, and he's the union president as well. And he doesn't, I would, if I was him, I'd be saying, I don't want to see any of my firefighters get in trouble. And I don't want my new member to be harassed for no reason. Let's get out ahead of this.
Right. I didn't really see anything here where he's off the map with respect to the flag issue.
Yeah.
Now, the fact that he had a blow up with one of the chiefs, well, I think that's kind of routine when management speaks to the union people. I mean, things.
Well, it is
kinda
up
get
here in the
heated.
Northeast, my friend. I'm not sure if it is in Colorado.
Well, I mean, so long as nobody's throwing haymakers, okay, so voices got raised. Big deal. It happens.
Yeah. Well,
You know,
we'll see.
It's interesting, and it really speaks to the diversity that's we're seeing now in the fire service and public service everywhere. Really, it's not just the fire department, and there's more to it than just saying, "Hey, let's do A." Well, okay, well, it's cause and effect. If we're going to do A, then what about B? Like, is there training involved? How do we prevent incidents? I remember cultural sensitivity training when that first came in to the police department. And you absolutely have to have that nowadays. If you're going to have a diverse community, if you want your workforce to represent the community, well, then education naturally has to be a part of that.
Yeah, and I think change the facts a little bit in this case, and we might have a different perspective on it. If he's not the union president, and he's just the quartermaster, once he's told that this is a religious accommodation, I think that's really
Pretty
the end
much
of the
it.
quartermasters.
Yeah, I would agree with that.
But I think that's where his union, he puts his union hat on and says, okay, now, we have a fire chief and we have a union president, and ideally they should be working together for everyone's best interest.
In a
But he's
perfect
got a
world.
job to do. And I don't know. I know how to come out where I come from, but I'm not sure. I'm not sure how it's going to come out here.
Well, like I said, it looks like his inquiry was for a righteous purpose, and that he wasn't trying to, denigrate anybody or do anything wrong. And like you always say, we only have one side of the complaint, so one side of the story.
Oh, that's for sure. All right, we get into a little criminal activity here in this next one. We've got a apparatus accident, and the involving an engine. The engine was not responding to an alarm, but it was traveling 47 and
miles
30
over the speed limit.
Yeah. And apparently now it looks like this was a straight post-accident testing. It was not, it does not appear to have been a reasonable suspicion test, but the driver of the apparatus was tested, and he tested positive for THC. And how's your knowledge in this area, Bill?
Very limited. I could talk you deaf, dumb, and blind about DWI back in the day.
I know.
And it's all changed.
We had a century of science that went behind that 0.08, and right now we're in the Wild West days here when it comes to THC, and I think that there's states are trying to draw the line at. In this case, it's an Illinois case, and their limit is 5 nanograms per milliliter of blood, which is the standard. And he was at 19 with apparently a plus or minus of 4. So at best, I guess he would be at 15. But there's a great deal of disagreement among the experts in this area about what is impaired. And so I guess we'll have to wait and see. But he is charged right now. He's charged with, there was a fatality in the accident, so now that just compounds it. He's charged with DUI, aggravated DUI resulting in death, and reckless homicide.
The pictures that I found look like a straight T-bone collision. And I couldn't tell because the photograph shows the back of the civilian vehicle, if it crashed into a building or stopped just short of it.
Mhm.
And apparently she died, the operator of the civilian vehicle died from blunt force trauma to the chest.
Yeah.
The only damage on the engine is the front bumper is twisted, which is really an excessive amount of damage, you know, without seeing the damage on the car. It looked like that rig had to hit something much more substantial than what it did to cause the damage that it did.
Mhm.
But I mean, it doesn't change the facts of what you've got here. And even if you take the DWI part or DUI part out of it, you've still got a negligence case at an intersection.
Yeah, and I think you definitely got that. I mean, I want to kind of probe your thinking on this. The reckless homicide. Many states have we call it negligent homicide, but vehicular homicide, which has, you've got to be grossly negligent. This is reckless homicide, which kind of, I mean, I'm assuming that's a little bit like involuntary manslaughter.
Without seeing their statute, it's hard to say.
Yeah.
It's probably easier to prove that reckless charge. That may be why they selected that.
Well, so I wanted to probe you on the connection between 17 miles per hour over posted speed limit and reckless.
Facts and circumstances.
Yeah.
It depends.
Yeah.
We're not told what the weather was. The photograph looked like it was clear. It didn't look like it was raining, didn't look like it was snowing, but we don't know. Could 17 miles an hour be reckless? Absolutely.
Mhm.
Depends. Do you slow down in a heavy rain? If you normally drive 65 and a 55 and it's raining cats and dogs, do you slow down because you can't see in front of you? Of course you do.
Mhm.
So what may not be reckless on one day may be very reckless on another day.
Well, I know some police officials that I've had the pleasure of going to court with have arbitrarily said 15 over is reckless. Others say 20 over is reckless. Others say 25 over is reckless. And I didn't know. That's what I was trying to. I didn't want to put it out there. I wanted to see if you'd come up with it. And
I wouldn't raise my hand and testify to that.
Yeah, that's how I look at it. But I know there are police officers out there, and I'm sure they didn't just make it up. It's their department's perspective. But at a certain point that they would charge someone, and 17 over, I'm not, it's negligent. It may be grossly negligent. Reckless, the model penal code definition for recklessness is consciously disregarding a known and substantial risk of harm.
Right. You see the risk and you say the heck with it.
That's right. That's, but it's got to be a consciously disregarding, whereas negligence is more or less careless. You had a legal duty to do something in a way and you were careless in doing it. Recklessness requires a conscious disregarding of a known and substantial risk. So, could 17 in a 30? Yeah, I guess it could be, but I know. Go ahead.
There's a difference between 17 miles over in a residential area than 17 miles an hour, on the interstate.
Well, that's right. 17 miles an hour in a 10 mile or 15 mile per hour would be twice the legal limit.
Yeah, you're in a 15 mile an hour school zone.
Yeah,
you're doing double the speed limit.
Yeah. So I don't know, not good. And I guess one question I'll throw out there, if he is successful in getting an expert on the DUI part of this, and he prevails on that, what happens with the reckless homicide charge?
Again, without reading their statute, and I didn't have time to do it.
Yeah.
It's tough for me to answer that.
Yeah, I in the back of my head, I'm saying, is it the speed limit, or is it the speed limit plus the DUI that makes it reckless? You know, I don't know.
I'm kind of surprised that they didn't put an assault charge in here as well.
Oh, really?
Yeah. Well, think about it. For an assault, you need a physical injury.
Yeah.
What's the most serious form of physical injury? Death. But it's true.
Yeah.
So if
but now you got to show intent. You got to show intent for assault. Did he intend to strike that vehicle?
Well, we can have a reckless assault in New York.
Ah.
So that's why I say you gotta.
Is it the model penal code definition of reckless, or do you have some other willful wanton kind of, you know, that's one of the things. You start getting into state laws and they don't follow the model penal code. They just say, oh no, it's going to be willful and wanton. And then they have 1,500 cases that interpret what willful and wanton is. And,
you know, but you've got a fire engine involved. So arguably we've got a dangerous instrument right away, you know. So we have a reckless assault with a dangerous instrument. You know, I could come up with different charges than what's listed here, you know, and we're assuming that this is exactly what their penal law reads.
Yeah. Yeah, well, I guess the lesson there is, if you're even, and I believe he was a medical marijuana, or he was using, in fact, there was some question, I believe, that he was only using a, what do you call it, hemp, if this is the case I'm recalling. And if he was only using hemp, which is legal, he shouldn't have been anywhere near impaired if he was just using that low level. So I don't know. We're again back. We're back in the Wild West days when it comes to what's impaired.
Is there only one test? Is there a false positive here? What's going on?
Even you can have an expert say, like, for example, 19 nanograms per milliliter is impaired, and you have another expert that's going to say, no, it's not, and here's why, and here's all these studies. And part of the problem is that until recently, THC was a Schedule I drug. It still is Schedule I, but they're allowing research now much more so. But we don't have a lot of research. We don't have decades and decades and decades of research because it was Schedule I, and even universities weren't permitted, except with a special permit, to even do testing with THC. And so we're still sort of in the infancy stage here of trying to figure out what is impaired. And the experts are not in agreement. And I'm almost certain he's going to be able to find an expert to say that was not impaired. That expert will have research to support that. And the prosecution's got the burden, to prove beyond a reasonable doubt that he was impaired. And I've got a question about whether they'll be able to do that. And if they get the DUI thrown out, what happens to the reckless homicide charge? Don't know.
Time will tell. Time will tell.
This is a great week because we got so many different and a variety of cases here. So this next one, have you done this one? You want to take a shot at explaining the Minnesota two-hatter rule?
I thought this was a very interesting case.
Yeah, me too.
And I had to read the statute very carefully to understand what was going on here. There's a situation where you have a firefighter working in a full-time department. Was it White Bear Lake fire as a firefighter, and then as a call firefighter or a paid volunteer in Hugo fire. This is in Minnesota. Apparently, they're neighboring or very close by geographically. And this firefighter was answering the page for a fire in the Hugo Fire District, where she's part-time or fire department. And her career department responds in mutual aid. Mm-hmm. Acting on the instructions of a chief from her full-time department, she goes into the basement with, I believe, a captain from that department, find themselves waist deep in water and decide to get out, and in so doing, injures her knee. She ends up putting in for a disability retirement, which she originally gets as a non-line duty, and then that is subsequently changed to a line of duty disability with, I would presume, full pension benefits, but not from the Hugo Fire Department where she was part-time, but her retirement came out of her full-time job that she was not working for at the time she was injured. So it's a very interesting, very convoluted set of facts, but the way that their legislation is written, where it talks about to qualify for duty disability benefits, a firefighter must, for not less than 12 months before is the direct result of an injury incurred during or disease arising out of the performance of inherently dangerous duties that are specific to the positions covered by the Public Employees Police and Fire Retirement Plan. And nowhere in there does it say you have to be working for that department.
Mhm.
So that department, was a White Bear Lake fire, they screamed foul. And on appeal, the court found for the decision made by the administrative law judge, which said that, no. The way the statute was written, which we do find to be ambiguous, is not going to be corrected by the court. That's going to have to be corrected by the legislature, and her pension benefits stand. And I had to go back and read it very carefully. Very interesting.
Very precise. And there's a couple of questions I have. The way they decided it, I mean, to me, it makes sense because she was under the command of her career chief and career officer. And I wonder if she had been totally under the command of her part-time department, whether or not it would have come out the same way. But they never really get into that part of it.
I think it would come out the same.
Yeah.
And the magic phrase is here, inherently dangerous duties specific to the positions covered by the Public Employees Police and Fire Retirement Plan. It doesn't say you have to be working for mom or pop, just so long as you're doing a job. And the key here is who's paying your insurance. Yeah. And her full-time job was paying her benefits, not Hugo. And that's how they ended up getting stuck with it. And they raise an interesting and a very valid point too, because how many people are doing this? Now, this is not common here in New York, or at least in my area of New York. Mm-hmm. Of course, as the fire service changes now with, less volunteers coming in and going to more paid people, part-time paid people, blah, blah, it's going to have a ripple effect. But her paid department, her full-time department does raise a very legitimate concern that they could end up paying pension benefits for people that aren't hurt working for them.
Right.
That's a legitimate concern.
Would your opinion change if White Lakes had not even responded to this? If this was just strictly a Hugo?
No, it would not. My understanding of how the statute is written is she's still good, even if White Bear Lake hadn't been there.
Yeah. And this is interesting because it goes beyond just an injury at a fire. It can get into cancer, other presumptive injuries, heart, lung, and has the potential to go beyond that. So
there's a lot of moving parts.
That's for sure.
But I was very surprised when I saw the title of the article. I was like, wait, what?
Yeah. Well, some people don't like the idea of two-hatters. It's funny. It's funny. Some of these same people go out and work, and they're union, and they'll go out and swing a hammer as a carpenter, and they're a non-union carpenter.
Don't cloud the issue with the facts. What are you doing?
You have a union, and they have non-union bartenders at their union hall. Right? Go figure.
You can't make this stuff up.
Yeah, don't point the finger of hypocrisy at me. But I don't know.
It raises very legitimate policy issue. It really does.
Yeah. So I don't know. I kind of feel like if somebody is full-time in one department, part-time in another department, that's fine. If they get hurt, both departments ought to contribute toward the person's pension or whatever benefits they're going to get.
Right.
On a pro rata basis. You put in 40 hours in one and 20 hours in another, that's how we're going to divide it up.
But we're stuck with what the statute says, and that's
right. No,
the way it's written.
Yeah.
So if you don't like it, call your congressman.
All right. I think we got one more. Saving the best for last. Boy, this is a tough one. Were you able to connect the dots in this one?
I did. I didn't read the entire complaint.
Okay. I'm still a little foggy on some of the things, but essentially it starts with a captain who wants to become an acting battalion chief, and there's questions about whether they can, whether they can't, and some other things. The next thing that sort of happens is, and I'm really at a loss on this one. He is the seventh arriving engine at a fire, seventh arriving unit at a working fire.
Presumably the last to the party.
Now he's a captain. There's also a battalion chief who's actually an acting battalion chief. Okay. But he is seventh on the scene at a working fire, where there's a policy that the second arriving unit will assume command. And no one's taken command yet. So he takes command, and then apparently in his own words, and he put this in the complaint, a shit show. The fire turns into a shit show. And he is apparently criticized for some of the decisions, some of the things that he did at the fire. Okay. But he, again, there was kind of back and forth. Did he do a good job? Did he not do a good job? And the chief said he performed adequately, but there were problems. So now comes time for his annual review, and the initial review seemed to be fairly good. He got performed well. After he had been shown it, the chief apparently took issue with some of the omissions that was in his annual review, sent it back, and it was revised at least once or twice. And the last time, according to him anyway, he refused to sign it because it lowered him. He still got performed well, but
the score was the same.
I'm sorry?
His outcome was the same.
The outcome was the same, yeah, but it lowered him, and he didn't feel it was appropriate. But then somehow his electronic signature got affixed to the revised one. He had signed an earlier one, and so why that's relevant, you'll see that he filed a state law claim for invasion of privacy, I believe it was, but that's basically because someone used his identity to sign that annual review. But at any rate, but at any rate, he filed suit when they wouldn't correct his annual review. And I don't know if he's got a relative that's an attorney. I don't know. It's the first case I've seen where someone files a lawsuit over their annual review. But I don't know what you would charge up front, but I know many attorneys, we take the cases, 50 grand up front. Take 20 now, 20 in another year, and 10, after that, but this review thing really bothers me. But he is alleging race discrimination. And
well, it's interesting that 2 battalion chiefs refused to change that review as well when it was sent back down the ladder.
Yeah.
Now, I don't know how reviewing and employee evaluation really goes in a fire service. I know how it was done in the police department, and the training on it is intensive. You study quite a bit for it. Even in the promotional process, there's a lot on the exams about rating and evaluating, and the errors that are inherent in the system, and this, that, and the other thing. But in this situation, if you were my boss, Kurt, and I had handed you this evaluation of this firefighter and you sent it back to me and said, change it, I wouldn't change it. You have the authority. If you think something was left out, you can append a page to it, or as many pages as you want. I disagree with, I'll say I'm the lieutenant. I disagree with the lieutenant's evaluation, and you're the captain. And then you kick it up, to the next level. And then they're going to look at what both of us have to say. I've been in this situation, and I've seen employees taken and given to other supervisors to be evaluated by a whole new, fresh set of eyes. There's nothing wrong with doing that either. But in my mind, and again, I agree with you, how does the officer on the 7th rig end up taking command? That makes no sense. And nobody bats 1,000.
And then criticize them for it.
Nobody bats 1,000. Everybody's going to come away from every incident saying, I could have done this better. We could have done that better. I mean, that's just in ESU, we did 3 ups and 3 downs. I don't know if you're familiar with that phrase, but we critiqued every operation. Nobody went home after a search warrant or after a, high risk arrest warrant, whatever the operation was. Nobody went home until the critique was done. And the critique was not done until we had 3 ups and 3 downs. And 3 ups were things that went well. And the 3 downs are things that did not go well, that could have been done better. And that sets the stage for future training, et cetera. And no matter what the incident is, you can always find a minimum of 3 things. And it forces you to really take a good look. It has to, the rule was, when we did that, there were no ranks in a room. That doesn't mean there were no bosses there, but it wasn't, the atmosphere was, you could say what needed to be said, because what we were doing was so above and beyond what the normal, police job is. So we needed to have that. And of course, whatever was said in the room stayed in the room. Now, whether or not it's still done that way, I don't know, but that's the way it was when I was there. And that was a great way to do business. And if I can't say to you, hey, Kurt, you left me in a lurch there. I needed you. I turned around, you weren't there. Well, you have to be receptive to hearing that. And okay, what can we do to fix this? If you're going to have a hissy fit and walk out of the room, well, you don't belong in this unit. It's that simple. And in my mind, in this scenario, if the officer on the 7th rig is taking command, you have a bigger problem of leadership here than this fellow that's showing up so late in the game. If anything, if you think he did something, I hesitate to use the word wrong, or could have been done better, or things could have been improved, whatever, well, then pull him aside and talk to him privately. Or depending on what it is, append your own report to the evaluation. Because presumably, it's still going to go up the line to the top dog. So I don't see the harm in doing that. To me, this seemed contrary to what I understand the evaluation process to be.
Yeah, when I was a career firefighter, we didn't have evaluations, so we didn't have to worry too much about that. And I know at the NFPA, when I worked for the NFPA, they did evaluations, and my concern is that sometimes they turn into a check the box activity that we got to do. Nobody likes doing it. We got to do it. We got to feed the bureaucracy the information the way the bureaucracy wants it done, and so it ends up taking on the nature of just a paperwork exercise as opposed to really being something. But I think one of the problems, this case kind of shows one of the problems when you're doing these evaluations and somebody takes issue or is able to create a narrative that they're the victim of some sort of misbehavior here in the process. And again, we have the allegation now. We have a court ruling that basically is throwing out the gentleman's claims, the captain's claims. We didn't get to that part of it, but his race discrimination claims have been rejected by the court. He's going to be allowed to bring his state law discrimination and also state law invasion of privacy claims back up in state court. But the federal claims under the Civil Rights Act and under constitutional claims have been dismissed. So it doesn't mean that they weren't legitimate, and certainly doesn't really mean much. He can still proceed, but I think it takes a lot of the wind out of his sails anyway.
Well, on its face, I don't see any racial component to this.
Yeah.
Again,
Unless if the first 6 officers at that incident were all white and nothing happened to their annual review, but he was gigged on it. But again, I'm not sure that constitutes race, even if that is what happened. And I'm not saying that's what happened. But I think if it had, then the court probably wouldn't have dismissed this.
But as usual, we're at the disadvantage. We don't have the whole story here.
Exactly. And it could very well be that he was downgraded for things that had nothing to do with what he said was the reason. He was saying that this was the reason. It very well could have been, there could have been some other reasons. I know there was something in the decision that discussed the fire chief had a list of shortcomings that he had, that she was kind of concerned that had not been in his annual review. And they ended up not making it into the annual review, but she wanted to make sure that there was something in there about that particular incident. So again, at the end of the day, the federal claims were dismissed. What do you think about that invasion of privacy? Maybe I'm misstating it. Was it invasion of privacy? What was the or identity theft? I guess
identity theft. I believe
identity theft. Yeah. What they took his signature apparently off of an earlier version of his annual review. There's a digital signature, and then put it in. He claims he refused to sign it. Is that really identity theft?
Maybe under Kansas statutes.
Yeah, I guess. So I don't know. So
it's certainly not appropriate.
No. Well, that brings us to the end of this week, and actually last 2 weeks, Bill. It's been a pleasure having you on. I really appreciate your pinch hitting here for Brad. And Brad's in Italy. I don't know if he's watching. Maybe he'll catch up. He'll see what a good job you did too. So
we'll certainly get the review from him.
Yeah, I'm sure we will.
I appreciate you having me on, Curt. I really do.
I'm very happy to have you on, and I think it's a big plus for what we're trying to do here. So, but folks, that's going to wrap it up for another edition of Fire Law Roundup. We'll see you again next week.